Supreme Court cases of the early Republic. Remember when we talked about how you can look at the Constitution and how the Democratic Republicans looked at the Constitution? They looked at it as you needed to use strict constructionism. You needed to read the Constitution line for line. You needed to pay attention to the Ninth and 10th Amendment. Basically, that the powers that the federal government has are limited to those that are specifically listed in the Constitution. Federalists, on the other hand, believed in loose construction. Federalists emphasized the elastic, or sometimes necessary and proper clause, and the commerce clause. And they saw these two things as creating what are called implied powers. In other words, Federalists, loose constructionists, believed that the federal government had more power than what was specifically listed, that there were also powers, if you read between the lines, are powers that are implied that our federal government is allowed to carry out. One of the cases that's going to involve this interpretation of the Constitution takes place in 1819, and it's McCulloch versus the state of Maryland. So, after Congress created first the Bank of the United States and then the Second Bank of the United States, there are several states, including Maryland, which opposed the creation of a national bank. They disagreed with the constitutionality of our federal government having a bank. They thought that banking should be left to private companies like it is today. And they charged a tax on the bank's branches because they disagreed with the bank. They taxed the bank for operating in the state of Maryland. James McCulloch is the cashier for the Maryland branch of the Second Bank of the United States. James McCulloch refused to pay the tax that Maryland had put on the bank's operation. And the Supreme Court hears this case and returns a decision. The court held that the power to create a national bank was supported by the Elastic Clause, but that states did not have the power to tax a national bank, as that would put state law above federal law. So, what does this case mean? It means that the expansion of powers in Congress, the implied powers, hold true. The Supreme Court has agreed with the Federalists. It might be important to note that the Chief Justice, John Marshall, was a Federalist, and that federal law trumps state law. If there's a disagreement between two laws, then federal law trumps state law. In this case, the state of Maryland cannot do something that's going to limit the federal government's ability to do its job. By taxing the Bank of the United States, the state of Maryland was making it harder for the Bank of the United States to help regulate commerce. Therefore, federal law trumps state law. The state is not allowed to tax the Bank of the United States. And here's that supremacy clause that the Supreme Court referenced. And here's a political cartoon about McCulloch versus Maryland. Another case from this era occurred in 1824 and took place between Gibbons versus Ogden. So here's some facts of the case. A New York state law gave two individuals the exclusive right to operate steamboats on waters within state jurisdiction. A steamboat owner who did business between New York and New Jersey challenged the monopoly that New York had granted, which forced him to obtain a special permit from the state to navigate on its waters. So the question before the state is, did the state of New York overstep its authority on a power reserved exclusively to Congress, namely the regulation of interstate commerce? And here's what the Supreme Court said. The court found that the New York law was invalid by virtue of the Supremacy Clause. The Commerce Clause applies across a lot of areas. So the significance of this case is that, once again, Congress, not the states, has the power to regulate interstate commerce. And when we say commerce, that includes a whole lot of things. Almost anything can be considered commerce. There have only been a few cases in American history where the Supreme Court has come back and said, no, that's not commerce. And here's another political cartoon. Another case took place in 1810, Fletcher versus Peck. And here are the facts of the case. The state of Georgia sold land to some companies. That deal was corrupt. There had been bribes given to legislators to make sure those companies were able to purchase that land at a cheap price. Whatever. The deal was corrupt. So when new legislators were elected after the corruption was discovered, they voided the sale. They said that all those claims from those sales are invalid. Peck, from the case, bought some of that land from one of the companies and then turned around and sold it to a man named Fletcher. Fletcher, however, would prefer to buy the land at the cheaper original price, so he argues that Peck had no legal right to sell the land. So the question before the court is, could the contract between Fletcher and Peck be invalidated by an act of the Georgia legislature? In other words, Fletcher would like the Georgia legislature to say that their deal is null and void and he should get to buy the land from the state of Georgia for a cheaper price. Can the Georgia legislature go back and invalidate a contract between two people? And here's what the court said. The court held that the Georgia legislature, or any state legislature, could not take away the land or invalidate the contract. The court said that laws annulling or getting rid of contracts or grants made by previous legislative acts were not allowed. Basically, since that land had been legally passed into the hands of a purchaser for a valuable consideration, even though there was corruption in the deal, then you can't invalidate that law. Probably more importantly is that second part of what this proves. This proves that the Supreme Court can declare federal and now state laws unconstitutional. In other words, judicial review, that power that the Supreme Court gave itself in Marbury versus Madison, that power to rule federal laws and acts by Congress unconstitutional, that now applies to state laws as well. And here's another cartoon. Another case from this era, Dartmouth College versus Woodward. In 1816, the New Hampshire legislature attempted to change Dartmouth College, which was a private institution, a private college, into a state university. The legislature changed the school's corporate charter by transferring the control of trustee appointments to the governor. In other words, the people who choose the board of directors for Dartmouth went from being individuals to now the governor. In an attempt to regain authority over the resources of Dartmouth College, the old trustees sued in court against William Woodward, who sided with the new appointees. So, the question before the court in this case is, did the New Hampshire legislature unconstitutionally interfere with Dartmouth College's rights under the contract clause? Here's that contract clause that we've been talking a little bit about. And here's what the court said. The court held that the college's corporate charter qualified as a contract between private parties, which means that you can't mess with it. The federal government can't mess with it. State governments can't mess with it. Any legislature cannot interfere with those contracts.